Okay. Good afternoon, everyone. Oh, it's on now. Good afternoon. My name is Jacqueline Steele, and I'm one of the competition chairs, and I wanted to take a moment to welcome you to the 2025 National Earle Zehmer Moot Court Competition. On behalf of the competition committee, we are happy to have you here today, and I wanted to give an introduction for the rest of the committee and then give you a little bit of information about the program and the things that led to the two teams who are our finalists and the argument that you're about to observe today. But on our committee, I have a fantastic group of colleagues who work to put this program on every year. Tracy Hyde, who is our law school coordinator, is over here to my left. We also have co-competition chairs, Amy DeGuzman and Alora Hodgetts, who work tirelessly to make sure that all of the pieces come together in every aspect of our competition for the students once they're actually competing. We had 22 teams this year who came from 8 different states, including Florida, Illinois, Kentucky, Michigan, Mississippi, Tennessee, Texas, and Virginia. And those 22 teams competed in preliminary and Sweet 16 rounds in July in order to determine what 8 teams would advance to have the opportunity to come to Orlando. Those 8 teams argued yesterday throughout the course of the day in our quarterfinal and semifinal rounds in order to prevail and be here today as finalists. So these students have worked incredibly hard, and I know you're going to really enjoy the arguments that you're about to see. One of the things that's really very important about our competition is that we enjoy the benefit of being co-sponsored by both the Workers' Compensation Institute and the National Association of the Workers' Compensation Judiciary. And we are one of the only programs in the country that affords students the opportunity to argue at every stage of our competition before sitting judges. That's not something that they get the opportunity to do, and we are very fortunate to have the volunteers from the Judicial College that help assist and allow us to be able to do that. We had 55 judges who participated throughout the course of this competition, and they came from 9 different states, including Florida, Georgia, Kentucky, Louisiana, Mississippi, Oklahoma, Tennessee, Rhode Island, and Virginia. And we can't thank them enough for giving of their time to help support this educational opportunity for the students. And so a little later today, when the judges from the First District Court of Appeal, another opportunity that our competition is, I think, alone in the nation in affording students the opportunity to argue before an appellate sitting judges. They come from Tallahassee in order to be here and to afford the students that opportunity as well, and we can't thank them enough for that opportunity. We're going to be giving out awards for the competition while the judges are deliberating, but before I go on any longer, I want to turn it over to Judge Eric Grindle, who was gracious enough to give a significant amount of time in preparing the problem that you're going to hear today. He's going to outline the highlights so that you have better understanding of the arguments that you're going to hear. And again, thank you so much, Judge Grindle, for your time in doing that as well.
Good afternoon, everybody. So let me tell you a little bit about our claimant. Our claimant is Carol Towing. Mr. Towing was injured initially in 2010 when he suffered an injury to his right foot. As part of that injury, he was prescribed with opiate medication and became addicted to the opiate medication, subsequently to heroin, and ended up in jail. 10 years later, he had cleaned up his opiate addiction and was working for Falls Grafs Towers, not spelled with a P, and suffered a right calcaneal, non-displaced calcaneal fracture. He had disclosed to his doctor about his prior opiate addiction. However, the doctor, because of a reformulation of some medication, decided to prescribe it to him as part of his therapy. It was an important aspect of his therapy that he be able to move his heel, and the medication was required. So over time, ultimately the calcaneal fracture healed. And his doctor started tapering him off the opiates, and unfortunately, he developed a condition called opioid hyperalgesia. And so what would happen is every time he got off the medications, he would get pain again in his heel. The doctor had written the carrier advising that the claimant was physically healed, but needed to continue with the medication because when he stopped, he developed this problem. Ultimately, the insurance carrier denied further opioid medication based on their position that the claimant had reached maximum medical improvement from his physical injuries. The doctor then wrote a prescription for a drug rehabilitation program. The court in this case came up with something of an unusual solution in that the judge ordered the carrier to continue to provide the opioid medication under what in Florida we refer to as the 120-day rule, but denied the drug treatment program as a violation of 440.021, finding that the need for the treatment program was an aggravation of pre-existing drug addiction, and so we have something of an odd result here, and so everybody here is going to try and resolve these issues. And thank you very much. The problem's a little longer than that, but I didn't want to keep you here all day.
Thank you. You may be seated. Good afternoon and welcome to the first DCA. We have one case on our oral argument schedule this afternoon, Fallsgraf Towers Construction versus Carroll Towing. Counsel for Appellant, when you're ready.
May I proceed?
You may.
Honorable Chief Judge, Associate Judges, and may it please the Court. My name is Kevin Fontenot, and along with my co-counsel Kate Franco, I represent the appellant and employer, Fallsgraf Towers Construction. I will be addressing the issue regarding morphine-CR treatment, and my co-counsel will be addressing the issue regarding...
Can you move the mic a little closer to yourself?
Yes, Your Honor.
There you
My
go.
co-counsel will be addressing the issue regarding the drug rehabilitation facility. May we reserve 1 minute for rebuttal?
You may, and there is a little feedback on his mic, so if it makes it a little difficult to hear. So we'll do our best and see where we go.
Yes, Your Honor.
Thank you.
Fallsgraf respectfully requests that this court reverse the order of the JCC awarding ongoing morphine-CR treatment for the following 2 reasons. First, this court has not overturned its precedent in Dixon requiring that the 120-day rule be pled as an affirmative defense, and it was therefore inappropriate for the JCC to invoke it sua sponte. And second, even if the 120-day rule had been appropriately invoked, the JCC still erred by disregarding Fallsgraf's actual challenge, which hinged on entitlement to benefits, not compensability. Turning to the first point, this court's precedent makes it abundantly clear that the 120-day rule must be pled as an affirmative defense or an avoidance under Florida compensation law. The 120-day rule, which determines the compensability of certain injuries under certain circumstances, would violate due process principles when applied without being included in a pretrial stipulation or otherwise being given notice to the parties at hand, because as this court has recognized, it violates principles of due process to dispose of issues at a JCC hearing without providing the parties appropriate notice of the issues to be decided at that hearing.
What do we do with our recent Ortiz case as to the 120-day rule, the application of the 120-day rule here?
Your Honor, the Ortiz case makes no mention of the 120-day rule and only refers to compensability in what is very likely to be dicta. In Ortiz versus Winn-Dixie, only the statute of limitations was at issue. However, the JCC invoked compensability sua sponte and determined that a 14-year continuous kidney treatment was no longer compensable. This court corrected course and stated that compensability did not need to be shown by any parties. However, this holding that the JCC erroneously relied on makes no mention of the 120-day rule, which is at issue in this case. They only described compensability. And further, Ortiz versus Winn-Dixie serves as a strong example of the procedural confusion that can be caused whenever a JCC invokes concepts like compensability without appropriate notice to the parties beforehand.
Now, the facts here, we have a similar extended period of the prescription, of the opioid prescription. Aren't I correct? It's been prescribed for a 4-year period, and there were some gaps in the prescription, but nevertheless, the prescription kept going. But at some point, the employee carrier said no more.
Yes, Your Honor. The employer carrier in this case has challenged the entitlement to benefits of Mr. Towing. Entitlement to benefits must be shown by showing that a compensable injury is the major contributing cause of a need for specific benefits. And entitlement to benefits can be challenged at any time. Here, Fallsgraf has challenged the causal relationship between the need for continued Morpheus-ER treatment and Mr. Towing's allegedly compensable injury. The record is clear that his calcaneal fracture has reached maximum medical improvement and that it is no longer being treated with Morpheus-ER. Further, while the record indicates that the employer in this case was provided notice of opioid-induced hyperalgesia being one reason for the medication being provided, the employer did not receive notice that addiction symptoms were actually being treated with the medication. Further, the symptoms being treated with the medication for opioid-induced hyperalgesia do not meet this court's standard of evidence to support the causal relationship between the need for specific benefits and the specific benefits themselves. Here, only...
So wasn't Mr. Towing's relapse of his drug dependency basically caused by the fact that he was injured on the job and he was prescribed opiates and he became an addict again, right?
No, Your Honor. It's not entirely clear from the record what the actual cause of his addiction here is, and that is why it is inappropriate to say that the major contributing cause of his need for medication stems from this most recent workplace injury.
Does it matter that he disclosed to the doctor before the new prescription that he had this prior addiction issue?
No, Your Honor. While this information may have been available to the employer in the sense that they could have sought out Dr. Ruka to determine that addiction symptoms were being treated, Dr. Ruka was not forthcoming with the employer in this case with respect to the medication being provided. Dr. Ruka only told the employer that medication was being provided for opioid-induced hyperalgesia. Here in this case, opioid-induced hyperalgesia can only be supported by subjective medical evidence. According to Dr. Simons' testimony, that is to say that only subjective evidence of pain, Mr. Towing's claims that he's experiencing pain, support his continued treatment with that drug.
But for some period of time, the employer carrier kept paying, right? During this 4-year period, MMI was reached, and yet the employer carrier kept paying for some period of time until they finally said no more.
Yes, Your Honor, the employer carrier did continue to pay. However, entitlement to benefits can be challenged at any stage, and as this court held in Checkers versus Whitehoff, the 120-day rule itself does not dispose of a challenge to entitlement to benefits. In this case, Fallsgraf Towers has challenged the causal relationship between his need for Morpheus-ER and his current injury, and that is not waived by the 120-day rule. And finally, procedurally, it has been waived, the 120-day rule, by the claimant in this case because they failed to include it in their pretrial stipulation. And for the foregoing reasons, Falsgraf Towers respectfully requests that this court reverse the order of the JCC. Thank you.
Thank you, Counsel.
Your Honors, can you hear me okay?
I can, thank you.
Perfect, thank you. Honorable Chief Judge, Associate Judges, and may it please the Court. My name is Kate Franco, and I am also counsel for the appellant employer, Falsgraf Construction. We ask this Court to affirm the JCC's holding regarding the denial of rehabilitation coverage under 440.02 subsection 1 because Mr. Towing is a habitual drug user. 2 reasons support our request. First, the plain language of the statute precludes individuals who have a habitual drug use. And second, this Court's precedent draws a bright line in cases involving opiate addiction, wherein individuals who stray from their doctor's prescription no longer can ask for coverage under Florida workers' compensation. Turning to my first point, the plain language of the statute. Florida Workers' Compensation Statute 440.02 subsection 1 is a definitional statute, and it very clearly states that an accident arising out of a workplace injury is not one involving an individual's use of illicit substances.
Isn't that just where the illicit substance causes the accident? Well, like if you show up to work drunk and you get hurt because you're drunk at work, this statute would prevent you from recovering, right?
Absolutely, Your Honor. This statute is
But in this case, this claimant was prescribed drugs from a workplace injury, and he became addicted to those drugs. That's a different thing, right?
Your Honor, Mr. Towing is still, this statute is still applicable to Mr. Towing's case because of this Court's ruling in Milmar Construction, which found that an individual's abuse of alcoholism prior to a workplace injury, which was unrelated to that individual's alcohol use, still precluded recovery with an alcoholism rehabilitation treatment because of that individual's abuse of a substance. Florida's legislature was very clear in being concerned with an individual's willful, self-inflicted harm. In this case,
How much evidence do we have that this was something beyond his use of the medication as prescribed by the doctor? The difference between some illicit use and him just complying with the doctor's prescription?
Your Honor, it's very clear in the record at pages 3 and 4 that Mr. Towing turned to heroin volitionally after his 2010 accident. Mr. Towing suffered a workplace accident in 2010. He was prescribed Naira ER. That prescription was at a physician's request. However, his event—
But does that matter that that happened prior in the prior case rather than in the case at hand?
Absolutely it matters, Your Honor. But for Mr. Towing's heroin use, even he has said that he does not think that he would have been so susceptible to an addiction to Morpheus ER. Both experts, Dr. Simonson and Dr. Rucka, discussed the prior use of heroin and its concern with prescribing Mr. Towing further opiates. The question here is relevant to the 440.02 subsection 1 preclusion of coverage because Mr. Towing's willful use of heroin precludes that drug treatment. Turning to my second point, this Court's precedent in Capps versus Buena Vista and Milmar Construction. I've already discussed Milmar's construction in this case. However, Capps versus Buena Vista is very important and will likely be brought up by my co-counsel as it was cited heavily in their brief. Capps versus Buena Vista looked at an employee who was injured in the course of employment, was prescribed opiates. Some time passed. That individual was re-injured at another employer and then was prescribed opiates and later requested methadone treatment. And this court very clearly said that what that individual was experiencing was an addiction to a prescribed medication. Mr. Towing was never prescribed heroin. He turned to that on his own. And this court in Capps versus Buena Vista said that this is what the legislature was concerned about.
But this case is a little more complicated, right? Because he was prescribed 2 things that led to that factor into this the problem that we have now for which he seeks benefits. particularly the second prescription, which seemed to re-engage and cause the need for the continuing prescription in the view of the doctor. So we're not dealing with just his own decision. Why not, at the very least, isn't there a proration thing that needs to go on here between, okay, what is the relative cause of the first prescription, the second prescription, versus his individual usage?
Well, Your Honor, to answer the initial part of your question, the facts here are a bit more confusing, but luckily the statute is very clear. The statute says that an accident at work is not one even due to an accidental aggravation of drugs, which we will readily concede is what occurred here. No one is suggesting that Dr. Rucka intended to cause Mr. Towing to be addicted to morphia CR, but that's where we are, and workers' compensation looks at ensuring that the industry covers the workplace accident, not that the industry should act as some sort of general health insurer, which is exactly what this court said in Capps. Fallscraft Construction is not Mr. Towing's hospital of choice. It is the responsibility of Fallscraft Construction to provide Mr. Towing with the workers' compensation claims that he requested for his right heel fracture, which, by the way, he has reached maximum medical improvement for. What Mr. Towing is instead asking this court to do 4 years after he realized he was addicted in 2021 is to now seek rehabilitation treatment. The time lapse between when Mr. Towing realized he was addicted and then is now asking for rehabilitation treatment is puzzling and can only point to him as, unfortunately, a drug-seeking individual, the very type that the Florida legislature was intending to prevent treatment of when writing 440.02 subsection 1. Again, we ask this court to affirm the JCC's holding regarding the 90-day inpatient drug rehabilitation center. Thank you.
Thank you, Counsel.
Good afternoon, Your Honors, and may it please the Court. My name is Rachel Woods, and I, along with my co-counsel Nayeli Diaz, represent the claimant, Mr. Carroll Towing. I would like to reserve 1 minute for rebuttal.
Noted.
Thank you. There are 2 issues before the Court today. I will be addressing the first regarding the morphia CR prescription, and my co-counsel will address the claim for the 90-day rehab. The Florida legislature mandates that the workers' compensation system ensure the prompt delivery of benefits to the injured worker using an efficient and self-executing system that is not an economic or administrative burden. In line with this purpose, the order of the JCC regarding the Morpheus ER prescription should be affirmed for 2 reasons. First, Mr. Towing did not need to plead the 120-day rule in this particular instance. And second, the employer carrier cannot prove that the workplace accident is not still the major contributing cause of Mr. Towing's need for treatment. First, we agree with our friends on the other side.
Is that their burden or is that your burden?
It is the employer carrier's burden to prove that the claimant no longer needs the treatment and does not satisfy the major contributing cause standard, Your Honor.
Okay.
First, we agree with our friends on the other side that the JCC overstated the reach of Ortiz versus Winn-Dixie, but this court can still affirm under the Tipsy-Coachman doctrine because he reached the right result even if for the wrong reasons. The JCC was correct to hold that there is a carve-out to Dixon that was created in Ortiz by holding that when an employer carrier treats an injury as compensable and pays benefits for an indefinite period, essentially treating the injury as permanent, the claimant does not need to raise the issue of compensability when the employer carrier is challenging his entitlement to benefits.
So you're saying that this is not a 120-day rule case?
This is a 120-day rule case, Your Honor, but the claimant did not need to plead it in this particular instance. Dixon involved a very different situation where the dispute itself was over whether the employer carrier did deny treatment within that 120-day window, whereas in Ortiz, the employer carrier authorized treatment for UTI-related injuries and continued to pay benefits for 4 years without complaint until denying treatment. That is very similar to what happened in this case, as can be seen on page 7 of the record. Dr. Ruka's March 2021 note put the employer carrier on notice that the calcaneal fracture had reached maximum medical improvement, and they were now only treating the opioid-induced hyperalgesia with the intent of tapering him off the medication completely or titrating him to the lowest possible dose, thereby treating the injury as permanent.
So was that the point at which employer carrier needed to speak up as opposed to waiting 2 or 3 more years? If they would have spoken up at that point, they could have made their arguments, and their arguments would have had more sway.
Yes, Your Honor. As you asked my opposing counsel, it does matter that the employer carrier was put on notice about this statute in 2021 and then waited 3 years to deny compensability.
Does that affect your requirement to plead an affirmative defense? Like, what's the relationship of those things?
Your Honor, in Ortiz versus Winn-Dixie, the case dealt with the tolling of the statute of limitations and held that the claimant does not need to raise the issue of compensability in addressing that claim. Here, the claimant does not need to raise the issue of compensability when addressing the entitlement to benefits after there has been such a long time between the acceptance of compensability and the denial of treatment.
But the nature of the compensability changed at some point, right? At first, they were treating a foot injury, and it evolved into treating a drug addiction. And so the compensability, agreeing to compensability on the foot, it seems, doesn't equal agreeing to providing drugs indefinitely for the rest of his life or what have you.
Your Honor, it still is compensable, and in Mims versus Confederated Staffing, the claimant suffered an injury at work, but the injury was later found to be completely unrelated to the workplace accident, and the JCC held that because the employer carrier did not deny compensability within that 120-day window, they were compelled to pay benefits anyways. Here, it's similar. The employer carrier was put on notice that the nature of the issue had changed, and they still continued to pay benefits, and therefore, Mr. Towing has relied on this treatment to be a productive and contributing worker for over 3 years now, and it would be unfair to him to revoke these benefits through a statutory loophole that would make the system less
But what if we agree with your rehab program argument? Then, I mean, it seems like these two things are at odds. Is he going to get drugs the rest of his life, or is he going to go to a rehab treatment program and get cured? There seems to be tension there.
Your Honor, Mr. Towing does not want to be on this medication. The record reflects that he has tried to himself stop this medication on several occasions. So he does not intend to be on the Morpheus ER for his entire life, but he has to be on it through the rehab program, and that cannot be prescribed by the program itself. It has to be prescribed by his authorized physician. So again, Dr. Ruka's note indicated that they intended to taper him off, and he would still like to come off of this medication. Further, the JCC was correct to hold that the claimant did not need to raise the issue of major contributing cause, because under Pearson versus Paradise Ford and Pizza Hut versus Proctor, this court held that when there are 2 industrial accidents, major contributing cause does not need to be reproven. Further, even if this court finds that this case does not fall under Pearson or Proctor, the claimant will still prevail on major contributing cause, because unlike cases such as Tico Energy versus Williams or Checkers Restaurant versus Whiteoff, where the need for continuing treatment was the result of a new issue and the kind of treatment was different than the one that had been furnished, Mr. Towing is only asking for the continuation of the same treatment that he has been receiving for 3 years. So as this case shows, requiring the claimant to raise the affirmative defensive waiver in proceedings such as this, where it is clear that the employer carrier has accepted compensability, allows the employer carrier to add statutory loopholes to avoid their burden. And therefore, this court should affirm the decision of the JCC as it relates to the ongoing Morpheus ER prescription. Thank you.
Thank you, Counsel.
Your Honors, and may it please the Court, my name is Nayeli Diaz, and I too represent claimant Mr. Carroll Towing. I will be explaining why the JCC improperly applied 440.021. Issue 2 is about Mr. Towing's ability to receive compensation under the Florida Workers' Compensation System for his inpatient treatment, despite his brief association with heroin. We respectfully ask that this court reverse the JCC's denial of compensation for 2 reasons. First, allowing 440.021 to be raised sua sponte is a violation of Mr. Towing's due process rights. And second, even if 440.021 is found to have been properly raised, because the workplace injury is the but-for cause of the need for treatment, it is still compensable. The primary purpose of the workers' compensation system is to ensure the prompt delivery of benefits so that the employee may be returned to work. Here, Mr. Towing was denied that ability because his due process rights were violated. Now, while my friend on the other side does note that 440.021 is a definition, that doesn't mean that it doesn't need to be raised. Often, definitional statutes are fact-dependent, as in this instance. For example, employee is defined under 440.0215, yet still, cases like Crum Services versus Lopez note that it does need to be raised as a defense. In this instance, Capps versus Buena Vista Construction Company, Milmer Construction versus Smith, and Pick and Save versus Parker all note that 440.021 is a defense that must be raised so that because it is barring the claimant's ability to receive benefits, so they must be entitled to defend against that and have their day in court.
If you lose on that issue, do you lose the case?
No, Your Honor, because even if 440.021 is found to have been properly raised, because Mr. Towing did what he was supposed to, it is still proper. Now, Judge Long asks my friend on the other side whether it matters that the claimant made clear to Dr. Ruca that he had a previous opioid addiction, and it does. Under Capps versus Buena Vista, they note something referred to as drug rekindling, meaning that when the doctor, the authorized provider, is on notice of the claimant's previous drug addiction, and they still prescribe a drug that could be addictive, it cannot be called accidental and thus does not qualify under 440.021. Dr. Ruca notes at page 6 of the record that he knew that Morpheus ER had a, quote, low risk of addiction, not no risk of addiction, meaning that it is not under 440.021's accidental. Further,
But anything that would have done something about the pain would have some risk. He picked that because it had a low risk, right?
right, Your Honor, something might have some addictive nature, but the mere fact that Mr. Towing did what he was supposed to do and made very clear to Dr. Ruca, as noted at page 4 of the record, that he had this previous opioid addiction, that he had been clean for 10 years, and had no want to be another statistic, it cannot be called accidental, regardless of the medication, but in specific in this case, because the medication did have some risk that the doctor was aware of at the time that he prescribed it.
So your opponents suggest that maybe the doctor messed up, but that they shouldn't be responsible for that. What's your response to that argument?
Your Honor, under drug rekindling, the doctor may have made a mistake, but that is not Mr. Towing's fault. Also, my friends on the other side place great emphasis on Milmer Construction versus Smith. However, while this case does certainly fall somewhere between Capps and Milmer, it is closer to Capps because there are 3 reasons why this is sufficiently dissimilar from Milmer. First, the claimant in Milmer was an alcoholic for several years prior to any workplace accident and had even been in alcohol treatment twice before the first workplace injury. Here, the genesis of Mr. Towing's addiction, as Judge Osterhaus noted to my friend on the other side, the genesis of this addiction was that first workplace injury. Second, in Milmer, that claimant was a volitional alcoholic before any alcohol or drug came into the picture because of medicating from their workplace accident. And third, even after the claimant in Milmer received 2 weeks of rehab from his physician, he returned to alcohol. In this instance, Mr. Towing has done no such thing. He has made it clear that his time in prison after his first misstep was a gift. He notes on page 4 of the record that it allowed him the opportunity to be clean. And because of that, he has no want to be another statistic in this instance.
Does it matter that he settled the disposition of the original case? What impact, if any, does that have on the current case?
Your Honor, when the previous claim was settled, at page 4 of the record, it does note that Mr. Towing nor his provider or the employer in that instance were aware of his dependency at that time. It was only after it was settled that they all became aware that Mr. Towing had a problem. And as noted in 440.028, modifications to settlements are nearly impossible. So, unfortunately, Mr. Towing turned down a path that many might not approve of. But the fact of the matter is that this happens to people all over the country. But Mr. Towing is by no means a career drug abuser. He's a man who had a misstep only because his first workplace injury caused an addiction. In this instance, Mr. Towing is closer to the claimant in caps. Had it not been for that first workplace injury, Mr. Towing would have never had any exposure to opioids. He would not have turned down this path, and he has no intent of returning there. Therefore, we respectfully ask that this court reverse the JCC's denial of compensation because raising it sua sponte is a violation of his due process rights. But even if not, because of the drug rekindling principle.
Did you need to file a motion for rehearing in order to make that issue, bring that issue to us?
No, Your Honor. Alamo Rental Car versus Phillips notes that due process is a fundamental error and thus can be raised on appeal regardless of the fact that it wasn't raised prior. Therefore, we respectfully ask that this court reverse the decision of the JCC. Thank you.
Thank you.
May it please the court. Oh, can you hear me?
Yes, you
May
may
it please
proceed.
the court, and one issue on rebuttal. In response to Judge Roberts' question to the opposing counsel, it is actually the claimant who has the initial burden of demonstrating the causal relationship between the need for specific benefits and the specific benefits themselves. And here there is simply not objective medical evidence in support of that and to make that determination. And for these reasons, Fallscraft Towers respectfully requests that this court reverse the JCC's order of more VCR. Thank you.
Thank you, counsel. Appellee, sir, rebuttal?
May it please the court. Mr. Towing is not a perfect person. But if this court adopts the position of appellant, it would be holding that 440.021's text bars coverage for an involuntary addiction stemming from a necessary treatment prescribed by an employer-authorized physician for an industrial injury, even after, first, the employee had been clean for 10 years, second, he informed his doctor of the risk of addiction, and third, was nonetheless prescribed an addictive drug, yet again. CAPS's interpretation of the statute unambiguously forecloses this result. Therefore, we respectfully ask that this court affirm on issue 1 and reverse on issue 2. Thank you.
Thank you, counsel, and thanks to all counsel. Those were helpful arguments. We will take a short recess and reconvene here in a few minutes. Thank you.
Okay. While the court's deliberating, we're going to move on to the announcements as to awards. The competition has a variety of awards that are given based upon the preliminary rounds and a written brief. Before the students move on to oral arguments, they all have to, each team has to submit a written appellate brief, and there are 2 awards associated with that we provide during the course of the competition. And then in addition to that, when the preliminary rounds are argued, the 22 teams are arguing, so we hear from 44 students, and the competition presents an award to the single student who scored highest in those preliminary round arguments. So in this particular case, we have our best individual oral advocate from the preliminary rounds comes from Team 6, Brennan Grawn from Chicago, Kent. If Mr. Grawn would come on forward, or Ms. Grawn, so sorry. Congratulations to you, and we'll present the awards over to my left. Our best individual, or best brief award for the team that submitted the top scoring brief out of the 22 teams goes to team number 19 from Michigan State University. Yes. Congratulations. And our second place brief award goes to team number 2 from Cooley. Congratulations to you both. And then we will be in recess until the judges have completed their deliberations. Thank you so much.
Thanks. You may be seated. All right. First of all, we want to give you some comments, and then we'll announce who we believe is the winner. And I want to say you all did a wonderful job. This was quite a problem. It was not only the two issues that each of you took on, but it was multi-layered, and there was a whole lot going on. And I just applaud all the work that must have gone into knowing your problem, knowing the cases that are on the other side, and really doing a fine job at arguing your position. All of you across the board did an excellent job, and it's a tough problem that hits right in the joints of our jurisprudence, and so you did a good job, and it was a fun fun issue to get into, and one that we probably could go on to give an hour to each side to flush it all out. But alas, we didn't have that much time. But you all did a wonderful job with it, and just congratulate you for that. Judge Roberts?
Sure. I want to echo the Chief's comments. Y'all did an excellent job. You know, the lawyers who do appeals for a living hate it when we say that y'all are much better prepared than they usually are, but it's true. So thank you for that. Also, I want to thank you for, you know, we had a problem with feedback, and especially when we started out, Mr. Fontenot, it was really bad. It got better as it went along because they made some adjustments. You did a very nice job battling through that, and so I appreciate your fortitude in that. But all of you were excellent advocates. All of you had good comments on rebuttal. You listened to the questions we asked, and both sides would respond to questions that we asked on earlier counsel. So very good.
Thank you. Judge Long, anything to add?
Just a little. Really impressive, I think. I'll echo much of what they already said. This was a complicated problem, and there's a lot of things going on with it, and thinking about it from our perspective and the ways to sort of inquire and challenge you on it. There's a lot of different directions you could go. So I commend you for your hard work and preparation coming into it. All of you, I think, had a really excellent command of the facts and the law. You were able to promptly respond to our inquiries. Really, all of you had an excellent presence, I think, at the podium. You look comfortable and in control. And so excited to see what the future holds for you. Good job.
Thank you. Thank you. And I also want to thank the team that put this all together, the problem writing group, and all of you who worked on this. It was quite a problem, a good one, and for bringing all this together, bringing the students to town, just a wonderful service. And really thank you for your work and making it all happen. I don't have a list of everyone to thank personally, but I do thank you personally, all of you who are involved. Thank you very much. Now, our difficult task was to decide who the ultimate winner is, and after some deliberation, we decided that Appellee team number 3, Rachel Woods and Nayeli Diaz, are the winners this year. Congratulations. Well done, all of you. And with that, I believe that concludes. Oh yes, please tell us where you're from. From Michigan State University. Fantastic. From William and Mary. Well done. And welcome to Florida, all of you. And you did well. You did well. Excellent. Anything else?
No, I'm sure they'll just want some pictures with you.
Okay.
Yeah.
Fantastic. Well, we'll do pictures, and otherwise we are adjourned.
Yes,